I want to thank our government witnesses for being here today. And everybody is welcome, and I'm glad that we have a lot of interest in this issue, and there has been for several weeks or at least 3 months, I guess. Originally, this hearing was solely going to be focused on our annual oversight of the U.S. Immigration and Customs Enforcement. However, it quickly became evident that more oversight of the administration's entire family separation and reunification effort was needed. So I expanded the hearing to provide oversight of that specific issue as well as just ICE. In April this year, Attorney General Sessions announced a zero tolerance policy at the southwest border. This policy directed federal prosecutors to enforce our longstanding immigration laws and prosecute all individuals who cross the border against our laws. After all, when the laws on the books are enforced, it protects not only American citizens, but those seeking shelter and protection here as well. Remember, the Attorney General implemented this policy after the Department of Homeland Security reported a 203% increase in people crossing the border against our laws, and that 203% was between March 2017 and March 2018, and a 37% increase from February this year to March of this year, the largest month-to-month increase since 2011. The Attorney General's policy was well-intentioned and simple: enforce our nation's border security laws so that people would stop migrating illegally. We must remember that the border security also affects our national security. However, like many well-intentioned policies, there were unintended consequences. As a result of the administration's zero-tolerance policy, more than 2,500 undocumented immigrant children were separated from their parents. As of last Thursday, 1,442 of those children have been reunited directly with their parents, and an additional 378 have been released to other individuals under appropriate circumstances. However, almost 1/3 of the children, approximately 711, are still in government custody and are unable to be reunited with their parents. Of that 711, some were ineligible for reunification with their families for legitimate reasons. According to the administration, 120 were ineligible because their parents waived the right to reunify. 67 were not released because of what the bureaucracy called red flags, including child abuse and serious felonies that were raised during background checks. Of course, some adults were found to have not been related to the children with whom they were traveling. Over the last 5 months, federal authorities saw a 314% increase in adults and children arriving at the border fraudulently claiming to be a family unit. And of course, this is a dangerous situation, and any policy we have that encourages the perilous practice I just described, that policy ought to be revived immediately. No child should be used as a pawn, subjected to sexual assault, extreme heat, and also criminal behavior by smugglers or traffickers seeking to make a buck on behalf of the most vulnerable. Now, 431 children, the largest number of the 711 who haven't been reunified, were ineligible because their parents had already been deported. The administration claims that all of these parents elected to be deported without their children, But public reports, these public reports indicate that many of them may have not made an informed choice to leave their children behind. Some of the reports suggest that these parents weren't presented information in a language that they could even understand. So we ought to be disturbed, and I'm disturbed by these allegations, and I hope our witnesses are prepared to give us thorough answers. Although the administration has mishandled the family separations, it's also important to remember that this institution, the Congress, also deserves its fair share of blame. For years, Congress has failed to take a simple step, one simple step, that could have prevented the family separations we now decry. And that means repealing the Flores v. Reno consent decree. In 1997, as a result of years of litigation, the federal government entered into that settlement known as the Flores case. When the U.S. government first entered into that consent decree, it was a much needed step towards ensuring the humane and dignified treatment of unaccompanied, undocumented immigrant children often thousands of miles from their parents. The settlement agreement provided that undocumented immigrant children without their parents could only be kept in federal custody for a maximum period of 20 days. It also required the government to treat these children humanely and ensure the type of quality care we would expect for any child, whether that child's documented or otherwise, undocumented or otherwise, that we ought to expect them to receive that fair treatment. No one, Democrat or Republican, would disagree with that principle, I would hope. However, in 2014, in addition to Flores, a single federal district court in California dramatically expanded the scope of that consent decree by applying it to undocumented immigrant children who arrive with their parents, a move that even the previous administration, meaning the Obama administration, opposed at the time that court case decision was delivered. Under this single interpretation of Flores, the federal government faces a stark Hobson's choice: enforce the law and separate families by releasing only the children after 20 days, or keep families together by engaging in the past administration's catch and release policy. As Senator Cruz, Tillis, and I wrote in an op-ed on Sunday, neither of those options is good choices. That's why we believe the best way to ensure this crisis never happens again is to repeal Flores agreement, but only as it relates to the time limitations governing accompanied undocumented immigrant children. Some of my colleagues will claim that we would end all protections for minor children and just allow the government to detain families indefinitely. So that's not a true interpretation. In fact, nothing could be further from the truth. No one on our side of the aisle wants to end the humane standards of care required by Flores. If anything, given recent news reports, we are more than willing to statutorily enhance those protections. We also want to see families kept in federal custody. We don't want to see families kept in federal custody indefinitely or even long periods of time. As Director McHenry is going to testify, when families are placed on the detained docket, their cases are usually resolved in 40 days. In contrast, when families are released into the interior, they're given a notice to appear at a future immigration court hearing with little incentive to attend. That hearing occurs on average not 40 days, but 700 days after their release, assuming they even show up. And that's just the first hearing, according to the information provided to every single member of this committee during the closed-door briefing, cases can take anywhere from 7 to 10 years to complete. Worse still, almost 80% of the asylum cases are ultimately denied. It just doesn't make sense then to release families en masse and hope that they will show up in the future court date where they will more than likely be denied the right to remain in this country. But, and I'll say this again, if families and children are going to be kept in federal custody, they must be kept in facilities where they will be treated humanely and with the basic dignity that all people, no matter what their immigration status is. Unfortunately, recent media reporting I've seen suggests the federal government is failing miserably in the task that I just described. Over the last few months, multiple news reports have surfaced describing how illegal immigrant children, and in the case of family units, their mothers, have suffered unimaginable physical, mental, and emotional, and even sexual abuse while in federal custody. Obviously, that's unacceptable, and the American people expect better. We hear it from our constituents every weekend we're home. To be clear, this isn't a new issue. Some of the abuse dates back to at least 2012, and several of the most horrific incidents occurred in 2015, 2016. Now, I don't say that to imply that this is all the Obama administration's fault, because it isn't. But clearly, there is a larger systemic issue that needs to be addressed. Again, no one, no matter what their immigration status, should have to suffer such abuse. I am a consistent advocate for victims of domestic violence and sexual assault. So, I'm troubled by these reports. That's why Senator Feinstein and I have sent a letter to the Inspectors Generals of Homeland Security and also Health and Human Services, asking them to open an investigation. We've also asked the Inspectors General to look into practices, procedures, and policies that are in place regarding the custody of illegal immigrant families and children, and to make recommendations to both of us and the agencies regarding potential improvement in these practices. Also, I hope that our government witnesses are prepared to answer questions regarding these incidents, and describe in detail steps that are being taken to ensure no person suffers more indignities again. And none of us on this committee, including this chairman, is going to accept anything less. We've got a lot to cover today, so I'll now turn it over to Ranking Member Senator Feinstein for her opening remarks. But contrary to custom, we're also going to give Senator Cornyn and Durbin opportunities for short statements because as their chairman and ranking member of the Immigration Subcommittee. Senator